So I thank you for the opportunity to speak to you today about this issue of freestanding claims of innocence. I am Professor Kenya Brumfield-Young, a criminology and criminal justice professor and founding faculty of the Wrongful Conviction Review Internship at St. Louis University. But I come before you today not in my official capacity, but as a longtime citizen of the state of Missouri. Since 1989 alone, Missouri has exonerated over 50 individuals who've collectively served over 712 years due to their wrongful convictions. These cases indubitably highlight where there is a crack and a break in our system. I heard that we weren't talking about the victims enough. Well, the victims, when people are wrongly convicted, the victims also do not receive justice. In those cases, we have people serving time and actual people or actual offenders who are out in society and not being accountable for those particular crimes. I've heard these bills referred to as miscarriages of justice and unnecessary. However, states such as Texas, Oklahoma, Utah, all have freestanding laws that allow wrongfully convicted individuals to assert their claims. Oklahoma and Utah have established procedures which allow courts to grant relief in the cases of actual innocence without requiring procedural violations. Missouri lags behind most states in the United States in relevance to being able to raise these claims. We've heard a lot about the emotional impact and the family impact of both those who have been wrongly convicted. Another cost that we can look at is actually the financial cost. The human and financial costs of wrongful convictions are absolutely staggering. Incarcerating innocent victims for just over that 712 years that I just referred to has cost Missouri approximately $14 million in taxpayer funds. Additionally, there's an estimated $32 million that could have been earned by those who are out and able to work, according to the mean salary of those in the state of Missouri. So the total economic burden of wrongful convictions, including the DNA-based exonerations, is estimated at roughly $46.7 million. This figure doesn't include legal cost compensation payments for those who are wrongfully convicted by DNA evidence, who have been exonerated due to DNA evidence, or the resources needed to correct and expand these particular injustices. Missouri's approach also causes me pause. I often wonder if we've not created a second class of person who's being incarcerated by allowing only those who are on death row to be able to file such claims. We've heard arguments that some of the units are understaffed. Prosecutors' offices can't afford to process these claims. So what I'm hearing is even more of a need for a legislation like this to allow the court to correct itself. Because if we wait for staffing, which may or may not occur in some of these units, then that is also an indefinite period of time that a person who is wrongfully convicted may languish. I think Missouri has to join in the growing number of states that recognize freestanding innocence claims as a valid basis for exoneration. No one should remain in prison simply because the system lacks an avenue for someone to raise and provide proof of their innocence. Providing a clear mechanism for exoneration will reinforce not only the trust in our justice system, but also help to thwart future injustices. So I urge this committee to support legislation that allows courts to grant relief, correct its errors, basically solely on the evidence that is presented and the current standard that exists. Thank you.
Thank you, ma'am. Is there any questions for this witness? Judge Dolan.
Thank you, Madam Chairman, to inquire.
Please proceed.
Professor, thank you for being here today.
Thank you for having me.
I don't raise an issue with the underlying process of this case. I just have an issue as to when and where. Should this underlying issue of actual innocence be raised at what time, in what court, and in what part of the process? And again, I ask, as I asked previously, if you raise it in, say, the post-conviction relief process, which Rodney suggested 2915, 24035, and that claim is not found in favor of the movement, are they precluded from raising that claim at a different time, in a different process?
So I think that was a question that's best answered by counsel. I think Trish was probably best answered for that. I don't answer those particular legal questions. I look at programmatic questions. However, what I'm speaking to is impact and the lack of accessibility for those who are particularly not on death row to be able to assert these claims after they have exhausted their other avenues. So I thank you for that question.
That was my comment. I don't object to your underlying issue of the whole thing. It's just at what process, what part of the procedure, and would it result in claim preclusion at a different time? Thank you.
Thank you.
Other questions for this witness?